Hello friends, today we are going to discuss about Mental Health Care Act of 2017. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at NIMANS, Bangalore. In this video, I am going to discuss about Mental Health Care Act of 2017. What was the need of this legislation and how the chapters have been divided in this legislation. If you are able to go through this video, you will be able to remember the various sections of the legislation. And this video is targeted to psychiatrists, mental health professionals, advocates, mental health review board members, and also central and state mental health authority members. Let's understand about Mental Health Care Act of 2017. You'll be able to understand any legislation if you know what was the history behind this legislation. If you look at the legislation earlier, there has been a paradigm shift. The first legislation was Indian Lunacy Act of 1912. So this legislation focused more on providing custodial care. The custodial care is basically to protect the society from persons with mental illness. During that time, they were called as lunatics and they were called as asylums. So here you are protecting the society. Hence, it was considered as Indian Lunacy Act. After our independence, there was a new legislation was introduced. That was Mental Health Act of 1987. This legislation gave more power for treatment. Here, the psychiatrists and mental health professionals were given power to treat a person with mental illness and send them to community. Here, irrespective of the consent, the psychiatrists, doctors were given power to treat a person with mental illness. And there were huge amount of rights violation were seen, not only in the hospitals, but also in the community. In the community, it is public at large and also family members. Hence, a new legislation came into picture, that is Mental Health Care Act of 2017, which talks about protecting the human rights of persons with mental illness during the treatment. So, the Mental Health Care Act of 2017 came in. Again, it did not come all of a sudden. It did not come. It came with a reason. The reason was because of UNCRPD 2006, that is United Convention for Right to Persons with Disability. So this 2006, UN proposed this convention and India signed this convention in 2007. Once you have signed the convention, you need to align our legislation, that is national legislation. There were two important legislation. One is Persons with Disability Act of 1995 and Mental Health Act of 1987. So these both legislation were aligned and a new bill was proposed, and one of them was Mental Health Care Act of 2017. This legislation was to align our national laws with UNCRPD. That was the main aim. So hence Mental Health Care Act 2017 was proposed, drafted, and it was passed in the Parliament on 7th April 2017 and received the President assent also. So let me be very clear. 7th April 2017, the President gave the assent. And exactly, approximately almost 1 year down the line, on 29th May 2018, the central government enacted this legislation and it was notified. Along with this notification, there were important rules were notified on the same day. That is on 29th May 2018, the central rules for rights of persons with mental illness. At the same time, CMHA, Central Mental Health Authority rules, and Mental Health Review Board rules were also notified. Further, State Mental Health Authority model rules were also notified. So the three important rules were notified on 29th May 2018. Along with this, on 16th 2019, that is 16th 2019, guidance document for mental capacity assessment was also notified. So this was under Section 81. If you look at that, we need to have a capacity assessment document. It has also been notified. Further, list of essential drugs were also notified so that these medicines should be made available free of cost from community health center upwards. That means these medicines should be made available free of cost in district hospitals and also in the community health centers or taluka hospitals. From this and final on 18th December 2020, mental health care regulations were also been notified. That is Central Mental Authority regulations have been also notified. So with this timeline, let's understand how the Mental Health Care Act of 2017 is chapterized. There are 16 chapters and 126 sections, or also you can call it as clauses. Let's understand why this legislation came into picture and what was the objective of implementing this legislation. The objective of this legislation, there are two important. One is, this act was introduced to provide mental health care services for persons with mental illness. That means the state is taking the obligation of providing services. This is the first health legislation which tells the state is taking the responsibility. Okay, one. Second, it also talks about to protect, promote, and fulfill the rights of persons with mental illness during the delivery of this mental health services. So these are the two important objectives this legislation was introduced. One is to provide services, mental health services to persons with mental illness, and second one was to protect, promote, and fulfill the rights of a persons with mental illness during the delivery of services. Services either could be in the hospital or maybe in the community also. With this preamble, now you should understand this legislation is for persons with mental illness, not for persons, for psychiatrists, or not for social workers or psychologists. No, we are part and parcel of providing service provider. This legislation is basically for persons with mental illness. That you have to see. This legislation should be understood from the perspective of persons with mental illness. You can't ask what is there for me as a psychiatrist, or what is there for me as a clinical psychologist, or what is there for me as a psychiatric social worker or a nurse, or maybe any other professional. This is basically for persons with mental illness. If you look at the chapters and also section, the first column is the chapter, the second column is the title of the chapter, and the third column is the various section. So there are 16 chapters and 126 sections. As you see, we will discuss each one of these chapters and also the sections. The first and the foremost, that is preliminary and definitions. That is section 1 and 2. Section 1, it talks about the title, where it is applicable. That is basically the legislation. And the section 2, across all legislation in India, it is more of definitions. That is the chapter 1. If you go from chapter 2 to 5, if you look at there, chapter 2 to 5 talks about the rights of persons with mental illness. What rights needs to be protected has been clearly mentioned in this legislation. That starts from section 3 to section 28. Let's go through each one of them. And further, if you look at chapter 6 to chapter 11. So chapter 6 to chapter 11 is monitoring bodies. What is the role and responsibility of the government? At the same time, it talks about central mental authority, state mental authority, mental health review board, and mental health establishment. That is from section 29 to section 84. And it is also talks about admission and discharge. That is chapter 12. Chapter 13 talks about responsibility of other agencies, that is basically police, judges, and other custodial institutions. It may be prison, it may be beggars colony, or it may be state home runs, or mental retardation home, or intellectual disability home. And if you look at the others, the chapter 14, 15, and 16, they are basically which talks about the various other miscellaneous which requires to run the legislation. Now let's look into the first. That is chapter 1 and 2. Chapter 1, as I mentioned, it is basically title, and the sections, the chapter, and also the section 2 talks about definitions. Here, the chapter 2 is basically section 3 and 4. The 3 talks about how we are going to determine mental illness. Although in definition, there is a definition of mental illness, but that is for the mental health review board judge, the person who is a chairperson. For him, that mental illness will be defined, that definition. Whereas here, for a psychiatrist to determine how the mental illness will be determined, it will be based upon international classification. That is now ICD-11 and DSM-5. That means prevailing international standard will be used. That means a person will be classified as a person with mental illness based on the classification for the professionals in section 3. That is how it should be read. Whereas, if you look at the mental illness definition in section 2, that is for mental health review board chairperson to determine what is persons with mental illness. With this background, let's move on. This is how if you look at the legislation, chapter 1 to chapter 1 and 2 and section 1 to 4, which have been clearly mentioned. Let's move further. That is, here I'm discussing about rights of persons with mental illness. That is chapter 2, 3, 4, 5. That is from section 3 to section 28. Here it is the rights have been enumerated. What are their rights? That means here a person with mental illness is not just a person with mental illness. You have to uphold his rights when you are providing services, either in the community or in the hospital. And here these rights are enumerated. At the same time, if a person loses capacity, how he should be treated, and he can write an advance directive, and he can nominate a nominated representative. If a person loses his capacity, this person will be taking decision. It may not be a family member, because this nominated representative is a very forward thinking, and also it has been found in India many family members are violating the rights of persons with mental illness. It is not only the professionals. Hence, the person with mental illness has been given a complete freedom to nominate anybody who likes. That is chapter 4. That is section 14 to 17. And finally, the heart and soul of the legislation. That is section 18 to 28. Here, various rights have been enumerated. So the heart and soul of this legislation starts from chapter 2 to chapter 5. This is where a clear discussion of determination of mental illness and capacity, advance directives, nominated representative, and rights of persons with mental illness from section 18 to section 28 have been clearly enumerated. Now, as I mentioned earlier, here you can see chapter 3 and chapter 4, AD and NR, and rights. This chapter 5 as rights have been given, rights of a persons with mental illness. And here, the first one, if you look at the section 18 talks about right to access mental health care. Right to access mental health care means the state will provide mental health care access in every district and in every taluka, that is tehsil, or you can call it as a community health center. If it is not available, the state will provide compensation. Imagine, this is the first health legislation which talks about providing a right for any citizen. Here, right to access for mental health care is not just for persons with mental illness. It is for any person. That means any person, he may not be citizen also. That is the way it has been put across. That means any person can ask for right to access for mental health care. So you can find all these rights which have been clearly enumerated between section 18 to section 28. Once we have enumerated their rights, now we need to have the duties of appropriate government, what the government will do. What the government will do has been in the chapter 6. That is, the responsibilities of the appropriate government. Appropriate government means central government, what is their role, and state government, what is their role. Why here central and state government? Let me remind you, health is a state subject, whereas mental health comes under concurrent list. That means both center and state plays a role here. That means the center will make the first legislation, and the second, the state will make a legislation in liaison with the central government, means that it has to be in sync with the central. And if there is any kind of tussle between the central government act and the rules of the state, invariably the central government will prevail. Central government rules or legislation will prevail. So here, the mental health care, both the center and the state has to provide the care. That has been beautifully, you should understand. So once you know about this, let's move on to the next chapter. That is Central Mental Authority. Central Mental Authority is a 7th chapter, and from section 33 to section 44, it talks about it. So here you can see the Central Mental Authority. What is the Central Mental Authority? How it has to be established? What should be the members' composition? What are the terms and terms of office, salaries, allowances? How the resignation is done? How the filling of vacancy has to be done? What are their roles, responsibility, and functioning of central authority, and also meeting of central authority? All these has been mentioned about the central. Basically, Central Mental Authority looks at the implementation of this legislation. That is CMHA. And at the same time, that is at the central government. But at the state level, Chapter 8 talks about State Mental Authority. That is, every state will have a state mental authority. From section 45 to 56, it is again the composition of state mental authority, terms and office, resignation, filling vacancies, what their roles and responsibilities, what is the functioning, and all those will comes under state mental authority. And here this at the state level, the state mental authority will be the important body, statutory body, which will be implementing the legislation. Further, if you look at the finance and audit of both state and central mental authority, how their finance will be taken, what is the account, what is the audit, where the budgeting has to come, and how they will monitor themselves. Further, the important comes is mental health establishment registration. Here, mental health establishment are all those mental hospitals. These mental hospitals are going to admit certain patients, that is person with mental illness. Here, when you admit a person with mental illness, one is voluntary admission, that means he comes himself for treatment. There are some patients you are going to admit against their wish and will. That means you are curtailing their liberty. Once you curtail their liberty, that is against the Constitution of India. That means Article 21 of the Constitution of India says right to life and liberty. That means you do not have any authority to take anybody's life. He may be a citizen or a non-citizen, you cannot kill them. That means not only kill, you cannot curtail their liberty. You cannot just put them behind bar or curtail their movement, freedom of movement. That means liberty is very important, right to life and liberty. If you have to curtail their liberty, that should be, a law should be there. And it should be passed by the parliament, and you have to follow this legislation. That is called as procedural law. That procedural law is nothing but Mental Health Care Act of 2017. So if you are going to curtail somebody's liberty in a place, that place is mental hospital, that mental hospital has to be registered. Please understand the constitutional perspective, because many a time mental health professionals, including psychiatrists, clinical psychologists, psychiatric social worker, nurses will think, what the hell, why this law is there? There is no law for any other medical practice. Why there should be a mental health establishment talk about admission, discharge? Please understand. The reason is we are curtailing the liberty of a person with mental illness. And if you consider a cancer patient, and he is maybe in the 3rd stage or 4th stage of cancer, he says, I don't want treatment, and you know that he's going to die. You cannot treat him against his wish and will. But for a person with mental illness, the power has been given to a psychiatrist to admit him and treat him. When the responsibility is being given, the power has been given, the responsibility also lies that when you are going to admit him, you have to register that place and notify whenever you admit him. So that authority knows a person, a citizen or a non-citizen has, his liberty has been curtailed and this place is registered, and the central mental authority or a state mental authority or a mental health review board member can go and visit those places. So here it talks about registration of those establishment in this chapter 10. Not only the establishment, but also the professional. These professionals needs to be registered. These professionals who are going to admit this patient against their wish and will. That is psychiatrist and also the clinical psychologist, psychiatric social worker and nurses. Of course, the legislation does not talk about registration of doctors. But considering invariably you have to inform the people who are in power, that is state mental authority or the central mental authority, you need to register there telling that I'm a mental health professional working under this legislation, so that if there is any software is available, for example, in Karnataka there is e-Manas. In e-Manas, if you want to admit any person, you have to inform the mental health review board that I am admitting a person against his wish and will. That is under section 89. You have to inform the mental health review board. That facility is provided by the state government in a software called as e-Manas. When the software is available, if somebody is admitting, the login credential will be given, so that when you provide information to the mental health review board, Mr. So-and-so, his age, his gender, his phone number, his address, his Aadhaar card number will be entered there, so that it will be informed to the mental health review board, this person is admitted on this date at this time. To enter those details, the credential has to be given. For that purpose, at least the psychiatrist has to be registered. However, there has been a lot of resistance by the doctors telling that why should we register? We are already registered under MHCA or under National Medical Commission. Invariably, the need of this legislation comes into picture. However, this is debatable, but registration of mental health profession is essential for that purpose, for admission. The second one is the legislation has to provide, that is, the legislation has to provide where are these mental health professionals available in their state? Suppose if a person is in Ballari and he is in one of the place called as Vijayanagara or Basangadi, in that place he is available or not, whether it is OPD or inpatient is available, so that the mental health person wants services can find them online. That means for enlisting purpose, you have to register. But anyhow, this is because since the legislation is not clearly mentioning that the doctors need to register, but again, this is a debatable. The state rules can ask for the professional to register. Moving further, that is Mental Health Review Board. This is a quasi-judicial body which will be seeing the implementation of the act at the district level. However, here it is from section 73 to 84. This quasi-judicial body has 5 members and the chairperson will be the district judge or a retired district judge who will be seeing regarding the admission, violation of persons with mental illness rights, advance directives registration, nominated representatives registration, if this advance directive is not valid or not valid, admission, discharge, if there is any litigation, those things will be monitored by the Mental Health Review Board. Further moving, admission, treatment and discharge. Here, when you admit a person, that starts from section 85 to section 99. Here it talks about admission of a voluntary patient, admission of a minor, admission of a person by supported means, that means a person who is involuntary admission is called as supported admission here, under section 89 for up to 30 days, under section 90 up to 90 days. That is more than 30 days, it is basically. So from there, it talks about all, even the emergency treatment is being discussed here. That is chapter 12. Moving further, other responsibilities. This is a very important chapter 13 where rights of other, responsibilities of other agencies have been discussed. That is the duties of the police, duties of the judge, what is the duty of the prison, at the same time, other custodial institution it has been talking about. That is from section 100 to section 105. How to remember the duties of the police? As you know, in India, usually when we dial 100, it goes to police. That is police helpline. Similarly here, section 100 is duties of the police officer in respect of persons with mental illness. It is easy to remember that. And also, if he is wandering at large, how the police has to take him into custody. It is basically, rather than taking him into custody, they will take him under their protection and produce them in the public mental health establishment. And then the doctor has to examine him, psychiatrist if he wants to admit under 86 or 89. And if you look at the section 102, it gives only 10 days reception order by the magistrate. It is not called a reception order. The magistrate has been given the power to keep the patient only for 10 days. After that, the doctor or the psychiatrist has to decide whether he will admit him as a voluntary or involuntary, that is supported admission, or he doesn't have mental illness, he can be treated in the community. That decision has to be taken by the psychiatrist. Further, if you look at the restriction of discharge of function by professional not covered under this, that is section 106. A separate chapter 14 has been talked about this. Here, please understand, it talks about restriction to discharge function by professionals not covered under the profession. That means a professional who is not supposed to do certain function which is not enumerated under this profession and under this legislation and also under his profession, if he does it, it is the contravention of the law. That means if a person who is allopathy need to provide treatment in allopathy only. At the same time, if a clinical psychologist is there, he or she cannot give medicine because under his profession it is not given. At the same time, a MBBS doctor or maybe a non-doctor admitting somebody in a mental hospital or maybe in a place where it is not registered under the legislation, if he is going to admit as a de-addiction center or something, they will be taken into task under section 106. So that is the chapter 14. If you move to chapter 15, it talks about offenses and penalties. That is section 107 to 109. So what are the offenses? What are the penalties? How much is the penalty? How much is the penalty starts from maybe 5,000 to 5 lakhs it goes up to, and also imprisonment up to 2 years are there. Moving to the last one is miscellaneous. This miscellaneous is basically from 110 to 126. It talks about power of the central government, power of the state government, who will make the rules, who will make regulation, and another one important landmark decision was taken by the parliament, that is section 115. That is presumption of severe stress in case of attempted suicide. That means whoever attempts to commit suicide will be considered as under stress by default. That means earlier, if you remember section 309 IPC, whoever has attempted suicide and he does not commit suicide and he has failed, he will be punished either by 1,000 rupees or imprisonment for 1 year or both. That means a person who is attempting suicide will be considered as a crime. Instead of helping him, there was a punishment. In Mental Health Care Act of 2017, there has been a paradigm shift. Here, under section 115, whoever attempts to commit suicide will be considered is under stress. He needs to give and support. At the same time, the state government has to make provisions so that he does not repeat. That means rehabilitation also has been talked about. But unfortunately, many of the states are not working towards it. Anyhow, this is the rights-based legislation. The citizen has a right to go to the High Court or the Supreme Court asking for his rights to be upheld. Let's understand, critically evaluate this legislation. Although this legislation gives complete power to a person with mental illness, but however, role of the family members have been completely undermined, because the studies earlier said that the family members were the maximum people who violated the rights of person with mental illness along with the society. Not only that, even it said psychiatrists, state agents, that is government officials, violated the rights. Hence, now this pendulum which is swinging from the custodial care to complete rights in empowerment of a person with mental illness. That means if you see, the law is basically the reflection of the society. Today, we have given complete rights under the parliament because persons with mental illness rights were violated. So that means society need to understand we need to have accommodation to persons with mental illness. And here, the family members, though their involvement is there, they cannot violate their rights. At the same time, family burden is enormous when providing care for person with mental illness. That can be clearly depicted here. If you look at this, the population of India is approximately 140 crore. In this 140 crore, 10% is suffering from mental illness. 10% means 14 crore. If the 14 crore requires professional care, what is the state's responsibility here? The state is providing care approximately in 70,000 beds. That is all mental hospitals, all medical colleges, maybe even district hospitals, taluk hospitals. If you count that bed, it may be 70,000. Remaining are provided care by the family in the community. That means we have empowered the person with mental illness, but not the family. This is going to be a huge problem in the long run. That means over a period of time, we may have to amend the law to accommodate the rights of the family. Otherwise, the family members will get burnt out, and the person with mental illness refuses to take medication. Family will say, I have a right not to look after you. And the state has to provide care for, imagine, there are 14 crore population, and even in that 1% of them are severely mentally ill. That means 14 lakh people needs to be taken care by the state. So it will be a huge burden. Today, it is hardly 70,000. That is 0.05% provision is given. What will happen? That means somewhere down the line, this law is heavily rights-oriented. This is my personal opinion. It is nothing to do with the institution where I work or the institution wherever I am associated with or affiliated. This is my personal opinion. Rights of the family should have been given more importance. Yeah. At the same time, we need to empower the family so that they can take care of a person with mental illness in the family. What are the different ways? The best way is, whenever the family wants help, availability of the police, availability of the ambulance, sending the medications to the family. At the same time, if the family requests for admission, in such a scenario, the ambulance should go to their house. And if a person with mental illness is taken care by a family member, It is not easy to provide a care for a person with mental illness by a family member. Family member will give at least 6 to 8 hours of his daily providing care for a person with mental illness. And for a carer, there should be a pension available so that even if he is working and he wants to provide care, he can leave the job and look after a person with mental illness. That would be in the true spirit of providing a care for a person with mental illness in the community by a family member, through a state providing a financial support, providing ambulance, providing medications, rehabilitation in the community. I will look for this Mental Health Care Act to move in that direction so that the family will be empowered in providing care for a person with mental illness in the community. I would like to see as minimum possible hospitals in the community so that a person with mental illness is provided care in the family so that they stay without rights violation from the state within the community. To summarize, my dear friends, this Mental Health Care Act is a positive step, amazing legislation, one of the best in the world, but most probably we have borrowed certain important components which empowers the rights of a person with mental illness, not giving importance to the collective rights, that is family rights. Capacity to consent for treatment, which talks about section 4, needs to be reviewed. There are some errors which needs to be corrected. At the same time, advance directive, nominated representative is in the right direction, but however, it will increase litigation and paperwork. At the same time, we need to have more workforce to implement this legislation. With the available resources, with available human resources, this legislation is difficult to implement because there are too many checks and balances, there are too many accountability. For whenever there is an accountability, that means invariably it will increase the time of documentation, it will increase the manpower, that will cost. That cost invariably in India, it will be transferred towards the lowest possible person. That means invariably the people or the person with mental illness or the caregivers will be bearing the brunt. That should not happen. That is my personal opinion. Further, if you look at the arrangement of Mental Health Care Act of 2017, it has been beautifully placed. First talks about the rights and talks about the role, statutory bodies, and then mental health establishment and mental health professional registration, admission of persons with mental illness, judicial and custodial care, and miscellaneous. These are the 7 important chapters you should remember how the legislation has been chapterized so that you can remember. So, my dear friend, Mental Health Care Act has taken a massive step towards the rights direction. Is it a right direction? The time will tell you. But however, the central government has made its commitment. Now each state has to make its commitment by forming central state rules, state mental authority, providing services, providing ambulance, providing home services, at the same time empowering family members to provide care of a person with mental illness at the doorstep will be the challenge, and the state has to take a proactive role in implementing this legislation. So with this comment, I would like to say Mental Health Care Act 2017 is a very good legislation, but requires huge amount of resources to fulfill the rights of a person with mental illness. Thank you very much for giving your valuable time. Stay safe.